Look, Mr. Gregory, and I'm not expecting for you to respond. I'm going to set this case for a pretrial conference on the same date as the other pending cases. You are facing a lot of jail time in these cases, and I don't want to hear any excuses from you today or at any time about why you're driving. I'm fed up with you! Constantly being in this courtroom driving against court orders while pending cases are happening. This is constant, well before Mr. Loftus was ever involved in representing you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you. And I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000 personal recognizance, not to operate or be in the driver's seat of another vehicle. Thank you, Mr. Loftus.
Alright guys, buckle up because today's courtroom chaos is off the charts. We've got not one but multiple defendants pushing the limits, judges forced to recuse themselves, and a familiar name making headlines again, Eric Martin. First up, we're diving into Con Autoroute Municipal Court where one individual, out on bond for driving without a license, somehow thinks it's okay to get behind the wheel again. And the judge? Absolutely fed up. You can already feel the tension as this courtroom drama unfolds. Stick around because by the end you'll see courtroom justice at its strictest, craziest, and sometimes most hilarious. Trust me, you won't want to miss a second of this one.
Okay, Ms. Sullivan, did you understand all of the rights and plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022. If you're not able to provide this court proof of insurance on the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean by non-political, whatever the fuck did you say? What did you mean by non-political, whatever the fuck did you say?
Take her into custody. Did you just use the F word in front of these kids? In front of me? Did you just do that? Take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids, and then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here.
Sir, come.
Get out of here.
Here's where we see why this judge is a legend. Mr. Gregory is literally thumbing his nose at court orders, driving against multiple restrictions while already facing serious charges. The judge's frustration is palpable. He's calm, collected, but every word is sharp, highlighting the absurdity of Gregory's repeated offenses. Setting a $5,000 personal recognizance bond and a strict, no driving order isn't just procedural, it's the court saying, I am done tolerating this nonsense. And notice the subtle intimidation, telling him he might as well just walk to jail if he reoffends. That's pure courtroom mastery in real time, firm, precise, and entirely justified.
Number 25W700388, the state of Michigan versus Bradley Peterson. Okay, counsel, Mr. Perpenwalk Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, for the record, please.
Brady Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably, and at this time I would ask to be allowed to recuse myself.
Next, we move to Miss Sullivan, and wow, things go off the rails quickly. What starts as a seemingly routine citation hearing turns explosive in front of children on a field trip. When she blurts out non-political whatever, the judge doesn't skip a beat, immediately taking action and putting her in custody. This moment is a textbook example of courtroom authority meeting reckless behavior. It's not just funny, it's a cautionary tale. Even minor missteps in court can escalate dramatically. And the children witnessing this? They're learning a hard lesson about accountability, respect, and the very real consequences of ignoring legal procedures.
All right, so counsel, you are asking to be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship, speaking-wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right, the court will note that there was a motion that was filed today asking for this court
For the videotape, hearing a bell and charges.
Okay, we don't have videotape. You can request a transcript, certainly. That's, yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and the charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It was
just on transcript.
recorded on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess. Because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts. You can just request the transcripts.
Okay, yeah.
There's a fee that you have to pay, but it's not a motion.
Now here's where it gets really interesting. In Judge D. Santos' courtroom, Mr. Peterson is already causing headaches, but this time it's legal strategy drama. His attorney wants out, not because of the defendant firing him, but because Peterson filed motions the attorney doesn't agree with. This is unusual and shows the complex dynamics of courtroom representation, especially when defendants act independently. For viewers, this highlights how legal strategy can be a battlefield, with attorneys balancing professional ethics, client demands, and the law. Peterson may think he's being clever, but the attorney clearly isn't willing to gamble his license on these questionable motions.
Yeah, I request that. Also, I request on the Michigan Court Rule 2.003. I believe it's filed that on the 17th on Friday or something like that. So
Okay, hold on, just one moment. Okay, well, counsel, I will allow you to, I will grant your motion to terminate representation specifically as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course. I would sure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. So the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
yes.
That's all of this one. You filed something on January 17th, and you're requesting our 2.003 to dismiss, disqualify the judge as follows. File the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at city and Wyoming public schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
not at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on them, specifically told them, case dismissed, that he cannot violate my constitutional rights.
Here's a classic blunder. Peterson is requesting a Zoom videotape that doesn't exist. The judge calmly explains that a transcript is what's actually available, and no motion is necessary. This is where we see the difference between procedural knowledge and overconfidence. Many self-represented defendants fall into this trap, thinking the courtroom works like a game they can manipulate. But reality bites back. Judges are methodical, precise, and zero tolerance for nonsense. And let's be real, anyone who hasn't mastered basic court procedure yet tries to argue over technicalities ends up making themselves look foolish while slowing down the entire process.
No, and I think that's the issue.
Oh, hold on, please, just one moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir?
I'm with you.
The allegation is that you assault or resist an obstructive police officer causing injury and trespassed.
That's just an allegation.
You're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they're allegations only.
Yeah, you need to read the whole thing, other than just one. I got like 15 issues in there.
15 issues.
Yeah, you
Okay,
need to
so-
read the whole thing. Also, Your Honor, I publicly protested today in front of your court,
Okay.
but none of your police came out to arrest me because that's my constitutional right to do.
You're
I'm not ignorant of my constitutional rights. I'm not ignorant. A judge told me a long time ago, ignorance of the law is no excuse.
Right.
And so I studied a little bit. I don't know a lot, but I know my constitutional rights. I've done read your European Constitution over and over again. Actually, I wrote.
This part is fascinating because facts and fiction collide. Peterson claims that the city of Woodhaven violated his rights, citing Judge Grant's rulings. But a closer look at the federal case shows the truth. His claims are mostly false. He selectively references dismissals while ignoring the injunction still standing against him. This is a great example of why fact-checking is essential, especially in court commentary. It's also incredibly dramatic. You have a defendant confidently proclaiming legal victories, while the documents tell a very different story. As an audience, it's a reminder. Courtroom bravado doesn't always align with reality. Clip 6. Finally, the judge lays down the reality of bond conditions, calmly explaining that restrictions aren't personal. They're designed to protect witnesses and society. Peterson tries to frame them as violations of his rights, but the courtroom logic is airtight. This is a teaching moment for viewers. Courts are not arbitrary. Conditions like no-contact orders, alcohol restrictions, or limitations on movement are standard in cases involving assault or disorderly conduct. The judge is patient, firm, and educational, showing how legal authority balances fairness with safety. For anyone watching, it's a perfect lesson in why courts impose boundaries, even when a defendant claims constitutional infringement. Clip 7. So, what did we learn today? Across multiple hearings, we saw judges enforce rules, manage chaos, and maintain courtroom integrity while defendants repeatedly tested boundaries. From reckless drivers to self-represented litigants misunderstanding procedure, the cases demonstrate how legal systems handle both the absurd and the serious. Key takeaways: courts are structured for fairness, but defiance has consequences. Attorneys are vital for navigating the law, and knowledge is power in court. If you found these cases as shocking, entertaining, or informative as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
If I followed your white laws, I follow them, and then you stomp on me when I followed your laws. You've been doing this for hundreds of years. You know, Martin Luther King marched, and you guys took dogs out.
Stop right now.
You're
I'm
right
not
about
100 years old, so do not accuse me of stomping on anything.
Well,
Let's be very clear on that.
yeah, well, okay, yeah, don't seem like it.
I'm not 100 years old, sir. Were you interfered with at all while you were engaging in your protest?
My constitutional right? No.
No, you were
I
not.
did at the city of Woodhaven, though, and now you condemning me for it
No,
because
sir.
you restricted me.
Sir, let me be very clear.
I've committed no crime.
I am restricting, I put conditions on for the protection of the complaining witnesses, which is the authority that I've been given with my judicial discretion.
You also
No.
took an oath to uphold every citizen's constitutional right to public protest. But
Okay.
you're not doing that.
Sir, let me clarify. Let me clarify something. There is a balancing act that as judges we have to do. So we have you're charged with a crime, right? It's an allegation. We have the protection of the victim and the community. All right? So there's a balancing act that this court has to do. And that is what this court is doing. I have not restricted all of your movement. I have not said you can't put signs up anywhere. You can't go on any public property. I have not done that, sir.
You did?
No. What I did was I addressed specifically the complaining witness and the victims in this matter. That is what I did, and that is what I have the authority to do that's been given to me by the U.S. Constitution as well. That's statutory authority. Whether you agree with that or not, sir. I understand you don't agree, but that's not a basis for this court to disqualify itself. Let's see what the next one is here. Okay, I don't know what bias favors are. I'm not biased, prejudiced, discriminating against you in any way, sir.
That's your opinion.
And sir, let me just be very clear. The court has not infringed on your First Amendment right of free speech. What it did is it put in protections for the victim in this matter.
I'm the victim. I'm the
Which this
victim.
court has every authority to do.
I'm the victim, and you're not recognizing that. I just protested in front of your courthouse and it was okay. You should have arrested me then. When I go to your
So
schools,
I don't
I'm your
have
wind
arrest
out.
powers.
When I go to schools and you're wind out, you should arrest me, but
Sir,
you're not going to. It's
I
my